Great. And with that, we are now live and recording.
Thank you. Welcome to the Appeals Court. I am Justice Meade. With me this morning are Justices Wolohojian and Massing will be your panel for this case. Each side gets 15 minutes. You needn't use all your time. We do not entertain rebuttal. With that, I'll call this case 2019 P1234, Commonwealth versus LaRoche. Mr. Rotundo.
Good morning, Your Honors. Attorney Rotundo for Mr. LaRoche. The first issue in this case deals with the index of charges that the jury was presented to the jury. It's our position that the charges that deprived the defendant of a fair trial. And the reason for that is this index invited like a checklist approach. The index included 5 co-defendants, all 40 counts on this chart, and what occurred in the case is that the judge allowed the jurors to write on the chart, and that was over objection by defense counsel. So it's our position that this chart caused some prejudice, where it took the jury's attention from the demeanor of the witnesses, and they're focusing on the trial evidence.
Mr. Rotundo, this is a kind of a complicated set of circumstances here. We have 6 defendants. We have 5 different victims and 41 alleged crimes. Why isn't this index just a chalk that helped the jury keep things straight, that the judge repeatedly told them that it was not evidence?
Well, I agree that that could have been the case. However, when the judge allowed them to use it to write on the chart, there was a curative, there was an instruction. He instructed the jury that the index was not evidence, and that was before the trial started. However, he only told them that they're not to use this as a checklist during his final charge, which and it's our argument that that was too late. That instruction came too late. So we run the risk of them checking off these counts when maybe based on evidence that was a prior bad act or something of that nature. So that's essentially the argument.
I don't understand. If I just want to ask you a hypothetical. We all agree the document was not admitted as an exhibit, correct?
Correct.
And the jury were instructed not to use it as evidence, correct?
Yes.
What if the judge, and that doesn't contain any extraneous information. There's no argument that there's extra stuff in there. It's pretty bare bones. It's an outline of the defendants and the counts attached to each defendant, correct?
Yes.
So it's sort of an organizational tool, as I understand it. If the jury had been given this organizational tool when they retired to deliberate, not throughout the trial, would you have seen any problem with that?
Probably not, because
Okay,
if
so that's sort of what I inferred from your brief. So what exactly is the prejudice that you argue occurred simply because the jury was given this organizational chart earlier?
Well, I think during the trial they were inclined to write on the chart, and there's a potential that they could have checked off a name associated with the count based on maybe evidence that of a prior bad act or evidence that should not have been considered, and and just generally using it as a checklist.
How would well, okay, so if we look at the verdicts as they actually occurred, I mean, I take it that your argument is that the prejudice is that it increased the risk that a defendant would be convicted of something he shouldn't have been convicted of?
Well, I think the argument is, there's a question of whether it influenced the jury or not.
What evidence is there that occurred? That the document itself created some prejudice?
Well, unfortunately, I couldn't have access to the document after it went into the jury room. And so I have no idea if the jury used it as a checklist. So I'm inferring.
Well, you know from the verdict, right, that they couldn't have just used it as a checklist, because they didn't convict this defendant or any other defendant of every crime with which he was charged.
That's correct. I agree with you on that.
So are you saying that we just don't have any evidence or indication in the record that the chalk resulted in prejudice in this case?
Well, I would only say that, I would assume that the jury the judge allowed them to write on the checklist. The judge allowed them to make notes and write on it. So I can only assume that it was used as some sort of in a way that was improper. But there's
In many cases now, the judges allow the jurors to take notes.
Yes.
I didn't check the transcript, but did that occur here, where the jury permitted?
I believe they did have notebooks.
All right. So why, if they're allowed to take notes in a notebook, why does taking notes on this document make any difference?
Because I think it's a little different. The document almost sets them up with this list, and they're more inclined to be able to check off counts, based on evidence that may not be admissible.
I didn't citing any federal cases. In federal courts, these kinds of chalks are used frequently because of, they often have these multi-defendant RICO cases. And I didn't see that you cited any case from the federal side. Do you know whether there are any federal cases that say that this kind of a, outline of the charges attached to a defendant is impermissible?
I do not have those cases. I know there are cases relating to summaries of voluminous evidence in Massachusetts. There were no mass cases that I found that dealt with these charts.
You're not arguing that anything in the chart was inaccurate?
No.
Right. The information in the chalk was accurate.
Yes, Your Honor.
You keep saying that they could have relied on prior bad act evidence, and that's in fact your second argument in your brief, that there was prior bad act evidence. I couldn't tell from your brief what prior bad act evidence you were talking about. Can you give me an example or two of evidence that was a prior bad act that was not a charged conduct?
Well, I think there were, Your Honor, I don't have it in front of me. I think with regards to the prior bad act argument, I'm going to concede to the Commonwealth's rebuttal on that. I did not prepare this appellate brief. I came in as subsequent counsel, and I support argument one relating to the this index. However, after review of the prior bad act arguments, I have to say that the judge was very selective as to what acts would come in and what would not come in. So I'm not in a position at this point to argue against that. I think he did a great job. She did a great job, I believe, and in limiting, what came in. That's really all I have.
Thank you for your candor.
That's all I have, Your Honor. Thank you.
Okay, thank you very much. Mr. Lynn?
There we go. May it please the court, Paul Lynn for the Commonwealth. I just have 3 points to make regarding the index. As my brother pointed out, the judge did instruct the jury specifically that this could not be used as a checklist. The jury is presumed to have followed that instruction. He repeatedly instructed the jury that it wasn't evidence, that it should be considered just like the indictments. It's a list of the charges, nothing more than that. Credibility was obviously the key issue at trial. The jury couldn't have failed to have realized that that was their job, to determine whether the residents were credible. And of course, the jury acquitted the defendant of 3 of the charges that went to them. So it is clear beyond any doubt that they did not use this index as a checklist. Other than that, the Commonwealth will rest in its brief unless there are further questions.
What is, I mean, the judge said don't use it as a checklist, just as if to say that using it as a checklist is a bad thing.
Correct.
What's bad about using it as a checklist?
Well, the defense argument is that as soon as they heard evidence of a crime, they would say, oh, that's that crime, and checked it off and not considered the credibility of the witnesses.
Bingo. Like bingo.
Exactly right.
Okay. Seeing no further questions, thank you both.
Thank you very much, Your Honors.